Mergers and acquisitions, that is our topic, and this is Nicholas. How do you help folks who are either looking to buy or sell?
Well, mergers and acquisitions is a fancy term for buying and selling businesses. And when it comes to buying and selling businesses, we help on both sides, both on the buy side and on the sell side. And really, what are we buying when it's a merger and acquisition? Mm-hmm. Well, when we're buying real estate, we know there's a property, we know there's land. When we're buying businesses, there's a lot more nuance and a lot more, let's say, in the ether. And we'll usually conceptualize this with the legal term of goodwill. And the goodwill is what the business owner has built over years, decades, the reputation, the elements with their clients and their relationships, whether it's with referral partners, vendors, and as a result, we have this intangible of money's coming in, but how? Yeah. It's like, well, it's through these reputation, through the relationships that we might call goodwill. And then in addition, what are we buying from a business? Well, also we're buying the money. I'm like, okay, this business is generating money, and there's a revenue, and there's some sort of expenses, and there's profit. And when it comes to buying and selling a business, often the value is going to start by looking at the numbers. And then there's elements beyond that that can start increasing the valuation. And then additionally, what are we buying when we're buying a business, or what are we selling? We're selling the intellectual property, the IP. And this is, in our society, considered an asset. And just like it's real estate is an asset, the business itself is an asset, the intellectual property is an asset. And that could take the shape of brands, that could take the shape of content. Maybe there are contracts in the legal world, that's intellectual property. Maybe there's video content, that'd be intellectual property. And really anything you can think of that could be copyrighted or trademarked or patented, this becomes very valuable as an asset because our system of government protects the owner. So you have a phenomenal patent, we can't just have 1,000 people doing the same thing. That creates a moat, a protection. And as a result, that adds to the value of what somebody is buying and selling.
Well, there's obviously so much to think about on both, whether you're buying or selling. When should somebody who's thinking of doing either get a lawyer involved? How early in the process for them?
Well, generally speaking, once the decision is made, it's worth to have a conversation relatively quickly. Even if there's not a deal that's going to happen for another 1 to 5 years, at least have a conversation. And generally we'll advise that folks talk to a lawyer, someone like us who specializes in this world, perhaps their accountant, ideally one that specializes in the M&A world, financial advisors, and some other professionals that can really guide the thought process in the early days. And as a result, the seller might give us a call, and if they're talking to us, we can guide them in who to talk to and guide them in some things to think about to start organizing and positioning themselves for sale and at the best valuation possible. And on the flip side, when somebody makes that decision to buy, give us a call where we can start talking about, okay, here's some things to look for. Where are you looking? We've helped other clients buy all sorts of businesses. Are you working with an intermediary, a broker, an investment banker? What are those conversations like? Why are you focused on this particular industry or this set of criteria for your acquisition target? And then we'll have these conversations, and then the client will go about their lives looking for the right acquisition, and they give us a call. Ooh, guess what? We found one, and we want to send them a letter of intent. And that's something that we'll help with, which is essentially a very simple document that's a persuasive document. It's a negotiation piece that outlines the main business terms. And from there, then we go to the next state of the negotiation, all the way through the nuances until finally there's an agreement and we negotiate the terms of that purchase agreement, all the way through the due diligence process, where once agreement's assigned, usually we enter due diligence, where the buyer is now looking under the hood and seeing, are these numbers real? And let's get some third-party verification. Starting to talk with some of the key leaders of the company, starting to actually walk the premises. Hey, let's go check out this warehouse, or let's go see the manufacturing of the widgets. And that's the whole due diligence process. And then we'll regularly be involved on the legal component of the due diligence, which means we'll look at every single contract. We will do the procedures to find out, are there any lawsuits going on? We will run certain title checks and do certain things on the legal side to make sure that everything is above board.
And, Nicholas, as you represent both sides, you work for both sides, it has to give you an advantage, when you're representing a buyer to understand the seller and vice versa.
Exactly. And so that is one of the huge benefits that we bring to our clients is we've represented both sides on countless transactions. And so generally speaking, a buyer wants value. That's it. They don't care what the price is. They want to get value. They want to get more for whatever the number is. And generally speaking, the seller wants the biggest number.
Sure.
And so understanding that from a foundational perspective really helps to set the framework for a negotiation.
So Nicholas, a deal's about to get done and you're ready to close that deal. That's important too, right? And how do you guys get involved in that?
Well, what's interesting is a deal is a deal, but it's not a deal until it's closed. And interestingly enough, depends on a particular deal, but a strong percent, in some instances well north of 60, 70, don't close. And so you could go through so much effort, so much time, so much cost, and then the deal doesn't close.
What happens typically?
Well, there's usually two main reasons. One, money. So maybe we had the money and we lost it. Maybe we had a lender and the lender said no. Maybe there was a lender that gave a pre-approval and then they changed their mind. Or maybe we had an agreement and this was the price, and all of a sudden the other side decides to adjust that price, putting it outside of a ROI such that it would make sense. So number one, it's the money side. And then number two is a monkey wrench that's beyond level of comfort. It could be, recently we had a auto body shop that's next to a gas station. Auto body shop being sold, the buyers were all excited, and then they found out there's some oil, gasoline spillage and some environmental details. The seller's perspective, not a big deal. We already took care of it. The buyer's perspective, oh, that's scary. We don't want to deal with environmental issues. We don't care that everything else is good. We're out. And so that would be an example of a monkey wrench. Another monkey wrench could be deception, where the moment trust is lost, really be very careful of doing a deal. Because if somebody lies in one detail, chances are there's a lot more areas that could be hidden from you. And so we'll generally advise when trust is broken to tread very carefully. And really in those situations, the best bet is either to walk away, there's always another deal, or the deal has to be so airtight from a liability protection and the price is so good that you don't care that there's more than likely going to be something that was a little bit fishy, but you expected that and priced it into the deal.
So Nicholas, what type of legal documents do you need to close the deal? What are those things? It's not just a closing deal document, right?
Exactly. So the moment there's a lender involved, the moment that happens, all of a sudden we have paperwork after policy, after checklist, after bureaucratic details, and there's no ifs, ands, or buts. It's, we need this document, period. And what do you mean? Like, okay, you need that document? All right, so the client calls me. All right, the lender said we need this one-page confirmation that we're the owner. Okay, cool. A couple days later, we need to see a lease. I'm like, but we own the building. All right, cool. Hey, we need a lease. All right, cool. A couple days later, we need to have proof that you have the 49% like your operating agreement said, but we already had that. Like, okay, cool. You want another document. A couple days later, we need to have some sort of a form that is our bank's form, and we need you to sign it. And then, of course, the client's like, what the heck does it say? Oh, let me review it. Let me give you the plain
Does it ever end?
Well, you just keep doing it until it's done.
Until it's over.
Could be
all
a
right.
couple of documents, could be a lot.
Yeah.
And that's part of the closing process. And again, what makes us really special is our responsiveness, where a lot of times a closing is a fixed time, 30 days, 90 days, 120, 180. And every day counts. And so if a client's waiting 3 days per document,
Request, yeah.
then there's 7, that's 21 days just lost.
Yeah.
Versus there's all sorts of other balls in the air. And so when a client is in closing, that's automatically becomes more of our VIP status clients of, okay, this is urgent, whatever they need, let's at least find out and see how quickly we can turn it around. And as a result, document requested, turned around, document requested, turned around, so that we're not deal stallers, we're not deal killers, we can be deal makers.